Hello everyone, I am Simran Verma, an aspiring chartered accountant, and today I will be presenting my views on the prospectus of Companies Act 2013. So, the first question which arises is, why does a company need to issue or file a prospectus? A public company, in order to offer its securities in the market for sale to the public, needs to issue or file a prospectus or a statement in lieu of prospectus to the registrar. The next question is, what do we mean by prospectus? The prospectus in the Companies Act 2013 has been defined in the section 2 to the subsection 70, which is as follows. Prospectus includes any document which is issued or described, or a shelf prospectus or a red herring prospectus, or a notice or an advertisement or any circular which offers a company's securities for sale in the public of a body corporate or a company or a body corporate in a wider term. Next section which we need to cover up is section 23, which is an all new section and relates to the issue of securities by a public and a private company. A public company can offer its securities for sale in various manners. First is the public offer. Second is private placement. Third is bonus issue or a right issue. A private company can offer its securities by two options, that is a bonus issue or a right issue or a private placement one. This section was mainly inserted in order to overcome the disadvantage of the Companies Act 1956 that clearly states that a private company cannot issue its securities to the public. So, this section was inserted. Now, I need to explain what does a private placement refers to. A private placement means when the securities are offered to a comparatively smaller number of investors, like investing in mutual funds, pension funds or banks. It is basically opposite to the public issue. The next section is section 25, which corresponds to the section 64 of Companies Act 1956. It is all about the deemed prospectus. Deemed prospectus. It is any document which is issued by the company in the market for the offering the securities for its sale to the public. The content specified in the deemed prospectus shall be the same that is to be specified in the prospectus. Any default in making the prospectus in making the prospectus the person who authorizes the issue of such prospectus shall be liable same as under section 34 to 35, which explains that a person committing fraud shall be liable to pay a minimum amount of fraud or 3 times the amount of fraud, or he will be liable to a imprisonment term of 6 months to 10 years. Our next section is section 28, which is a new section inserted in the Companies Act 2013, which explains that a member or members of the company, in consultation with the directors, can offer a part of their shareholding in the market to the public in order to subscribe the securities. So, and any document offering such issue shall be known as a prospectus. The next section is section 29, which corresponds to the section 68B of the Companies Act 2013. A public company making public offer and such other classes of company as may be prescribed shall issue the securities only through a dematerialized form. Any other company can issue its securities either in dematerialized form or a physical form. Initially, in the Companies Act 1956, a limit was set for issuing the securities in dematerialized form, that was 10 crore, issuing the securities in the market of 10 crore or more than that. Now this limit has been dispensed. Now, our next section is section 31, which corresponds to section 60A of the Companies Act 1956, which explains the facility which is available to any class of company or which as may be prescribed by the SEBI may file a shelf prospectus with the registrar at the stage of its first offer for a period of 1 year. Or a company shall issue the information memorandum on new charges created of any change in the financial position with the registrar of the companies prior to the issue of the second offer. Initially, it was limited to only public financial institutions or scheduled banks whose main objective was financing. But now, any class of company can, as prescribed by the SEBI, can issue shelf prospectus. Next section is Section 32, which corresponds to Section 60B of the Companies Act 1956, which is all about red herring prospectus. Red herring prospectus shall be issued prior to the issue of the prospectus and shall be filed with the registrar 3 days prior to the opening of the subscription list. Any variation in the red herring prospectus or the prospectus shall be highlighted in the prospectus. Earlier, it was like company has to individually intimate the registrar with the individual chain variations, but now it is like you need to only highlight in the prospectus. So with this we come to the end of the new sections of the prospectus, and at the end I would like to thank CA Connect India for giving me this opportunity to share my views on the prospectus of the Companies Act 2013. Thank you.